Hello, welcome back. This is Roger Royce, host of the 10,000 Startups podcast, legal strategies for startup success. Where every week we bring you live original content from a subject matter expert on a topic of interest, legal interest to a startup company. And this week we have a really great guest. We have Olga Mack, former CEO of Parley Pro. She's a lawyer, she's been an entrepreneur, she's been an executive, and she has become very much a dominant force in California and throughout the world in speaking about legal issues, especially IP legal around AI and associated rights. So thanks for being here, Olga. And I know I did not do you justice in that introduction, so maybe you could tell us a little bit more about yourself.
Oh, well, hello, Roger. We are actually longtime friends, so it's really good to have a conversation with my friend. I remember when I was an associate at Wilson Sonsini, and your office was right next door, and you were the entrepreneurial lawyer who inspired this monster. So I am your creation, and I'm in many ways, for many reasons, and I'm really grateful for your guidance, for your mentorship, for you being the role model, now talking to you live on the show. I think you did a pretty good job. I am a builder today. I love the future of law. I love legal tech as well. I spent a lot of time in legal tech. I am a tech lawyer by design, and I have practiced law for about 15 years. I've been in big law. I've been in Fortune 500 company called Visa, and then I ran away with circles of numerous technology startups. And I'm a former general counsel who basically have been in various technologies, cutting edge, disruptive technologies before they earned their buzz, before you heard of them. So I've been in AI, ML, crypto, blockchain, well before they have been covered in popular media.
Yeah, I'll certainly vouch for that. It seems every major trend of the last several years, you've been right there. You're the one who's told me it was coming and explained it to me. So I'm going to jump right into the topic that's on everybody's minds right now, which is artificial intelligence, AI. And I think in the legal industry, we're still sort of sorting out these rights and how it's going to play out. There's so many issues with AI. So maybe we could talk about a few of them. And the first one that comes up, I think, for our audience is really who owns this stuff? You know, where are the IP rights, and even what kind of IP is it? Even is it trade secret? Is it something we can patent? Is it copyrightable? Can you comment on that?
Yeah, no, this is very interesting. If we're talking about sort of generative AIs and large language models, LLMs, they have been trained on basically everything that is on internet. Um, and um, and of course that creates challenges because just because it's available doesn't mean you can take it. And I can give you many examples that that's true in law. Just because I put a $700 vase on my porch, you cannot take it because if you do, that's going to be a felony in San Francisco. I know it because I'm a former DA. I can tell you that it will be. Just because it's available doesn't mean you can take it. I actually prosecuted a case just like that. And that's how I know that you cannot do it. Same thing, copyright is probably the most important intellectual property right here. Just because you see a painting on my wall, just because I display it, doesn't mean you can take a shot of it and display it on your social media or in your living room. That's a bundle of rights that you may not have. Availability doesn't allow you to use, display in any way, or make what's known in intellectual property derivative work. So I think of what's happening with LLMs is that they collect a lot of information that is available, that may not be permissioned, and they create derivative work. And every time you create a derivative work using the input of stuff that you may or may not have rights to use, you are putting a big gray cloud on the title of your creation. And sure, if you are a technologist who is doing it, you're probably thinking, oh, fair use, right? Because that's what most people are thinking. And that's a great thought. Two things about fair use is that fair use is a defense. So that means is that you only use it because you did something wrong. right? You already stolen, that's already established. You're now saying, oh, but I have a good reason to do it. It's called fair use. So if you are thinking that you have fair use, you also, and you are prepared to argue for it, you also should allocate a budget to a lawyer to help you actually defend it. So fair use is a great thought, and we can talk about whether the use of LLM models on internet covers sort of taking what's not yours, either intellectual property or privacy related. But you need to be prepared to litigate. And if you are, that's where fair use could be your friend, but maybe not.
Well, let me use an example. So as a lawyer, somebody asked me a legal question, and back when I used to do research, I might go on a site that I paid for and look for statutes and commentary, or I might go out on one of the ones that are more broadly available, or I might pick up a book like this one and look up the answer. And then I'll put it in my own words, whatever it is, and I'll evaluate all the other sources. And I don't think anybody would ever say that if somebody read my book and came to a conclusion that they've infringed on my rights. Why is this different? Why is it different if you have a computer go out and make that decision?
Well, laws is a very special place. Remember, laws are generally publicly known. Commentary could be copyrighted. Creating templates, and provided that they're not completely copied from the statute, could create intellectual property. But laws, by and large, is very different than copying works of art, for example, or copying really sort of like things like novels or articles. So laws is a very special place, and there's sort of a history of there is a legal mandate of it being available. There is policy preference for citizens to know what they are. Laws often have templates, and so it's really actually a higher bar to create copyrighted materials in laws. That combined with laws essentially having a history of copying and pasting, I think law is a unique place and really should not be used as a way to generalize to more creative works like paintings and articles and stuff like that. So I would start with that. It is different, but not to much extent. In copyright still applies. However, there is sort of a massive component for citizens to have access to it. And the big difference is that you copying for the purpose of legal advice, doing it once or twice, is very different than a model, going across internet, copying, and then using it at scale. There is the scale difference. It's really hard to enforce with what Roger is doing, and frankly, the impact of one copying is really not going to be very much, because in copyright, for example, you have to show damages. And it's really hard to show damages, especially in any one case. However, when you do it at scale, and if you as a copyright owner can say that it actually decreased the market for the original, for example, nobody now buys my templates, then it's a different story, because it has an impact and it has damages. And it's an entity that does it at scale. It's not just Roger and his office or garage doing it. It is a company with assets that I can go after and show the impact and damages. And that's why this is when I said, if you should be prepared. If you're going to be doing it, you should be prepared to spend legal fees on that, especially defense.
Yeah, the law, that might not be a fair example, because there actually is a big debate raging over companies that go out and they get statutes and they just copy them and then publish them. Do they have any rights to that?
Statutes are different, but like if they copy enhanced version of it, that's when it becomes controversial, right? Mm-hmm. Because in law, there's sort of shades of gray of what's public, what's available, and what's enhanced. And frankly, that's a challenge with the industry.
Right. So I've noticed that several of the research sites that I use now, they put a little disclaimer, all of them do. They have this disclaimer. They say, by the way, you are not authorized to scrape our site with an AI tool. You could read it. I can't remember the exact legal language, but the idea is they don't want, they don't want AI taking our content and then
Yeah,
tuning
what you
audiences.
increasingly see folks using technology. You probably have been to websites where you cannot copy and paste. You try to copy and it doesn't allow you to highlight the text. There's technology for that. And then we increasingly, and actually this written on law.com, an article that we're gonna see the rise of permission technology. Basically, if you are a person or a company, you will inventory all your assets and you provide rights or not right, basically no trespass signs on your property for things like LLM probes.
Oh, yeah, that's interesting. Well, I can tell you that more as a practical matter. I mean, as a lawyer, I would never use that. I think every big firm in the country has prohibited their lawyers from using some of these new AI tools because they hallucinate and they come up with wrong answers, right? And
Well,
so,
that's again, it's so interesting you say that. What I tell lawyers actually is to look at their practice. Is everything, when you run your practice, and you run many practices, Roger, from kind of your own to mid-size to joining other to like doing all kinds of things. Business of law better than anyone I know, and you know that your legal practice does include things that are high risk, like filing things with the court, for example, or giving legal advice. Yes, that requires, if you're going to be using AI, working with a vendor that train their models on specific data set that is clean, permission, and doesn't hallucinate and all that. However, running a business involves many things, including business development and marketing. Those things could be automated using AI, and they're not confidential. I mean, by definition, marketing is something you do in the public. And so what I advise lawyers specifically is to rank all their tasks from high risk to low risk. And I recently wrote an article about it. And then actually experiment with AI and do low stakes experiments where definitely don't put confidential information of your client, definitely don't rely for research. Yet you can, for example, take a case and ask it to summarize a PDF and suggest 3 versions of a summary you send to a client based on the client's profile, whether they like extended version, a shorter version, a more formal version, or a more sort of colloquial, conversational version. You can do that, and that will greatly help you create efficiencies in your practice.
gotcha. Well, that leads into the next thing I want to talk to you about. I mean, you're very well known for your leadership in legal technology. And it's my observation that this is an area that is just changing so quickly. And I'm seeing kind of like old ideas now being recycled into new tech that it didn't work before because the tech wasn't there, but now maybe they will. But it's just moving so fast. And without violating any confidences or giving away anything you might be planning on doing, can you comment generally on where technology in the legal industry is going?
Yeah, I mean, legal tech is an exciting place. Absolutely. And, building on what we talked about AI, this is the first technology where lawyers, I call it nervous cider. They're both nervous and excited at the same time. On the one hand, most lawyers I know are very intelligent people. They do not like cutting and pasting, that do not want to do routine stuff. They want to up level their practice and practice on top of their license, so to speak. And AI kind of has that promise. And it does, as you well observed, give the functionality increasingly of things that we only had in our minds and now actually are able to build. And then on the other hand, it does sort of create this level of nervousness of, what will my job look like? Do I have enough skills? Will I be able to have the same standard of living or better for me and my family? And so that's why there's a lot of excitement and nervousness, and yes, a huge opportunity. And yes, the way we practice law is going to be very different 3, 5, 7, 10 years from now, for sure.
Yeah. It's kind of funny. You're talking about technology as a tool for the legal industry to use. About 10 years ago, I was on a panel with Vivek Wadhwa from Stanford, and his whole point was he kept saying AI is going to eat the law. Eventually we're going to replace you. We're going to replace you entirely. So fortunately, it hasn't happened yet, and hopefully I'll be long gone by the time that happens.
It's an interest. I've heard that, and I invite people to think about email. I remember going to college and for the first time getting my email. And the promise of that is that we will have, fewer letters and yes, with actually I don't have fewer letters. Do you have fewer letters because we have an email? I still receive a lot of mail. But that aside, I certainly do not have less communication. If anything, I now manage 3 inboxes and a bunch of messengers and various social media. I cannot humanly answer it all. And so I invite folks to look back at things like email and ask themselves, did that decrease communication? And the answer is no. And then I invite folks to take a look at various other technology trends, from the rise of privacy to cloud to all kinds of things. And if anything, a value of a good legal advice has been trending to command premium prices. So, so I imagine a world where some of the sort of more routine things could be embedded in software. And I really look forward when top, bright legal minds no longer have to do cutting and pasting or doing manual things and really use their minds to create better strategies and impact for their clients. And I think that's where we're going. I think it will absolutely change. But do I think that lawyers will be sort of a relic of the past, just like, a Pony Express rider was? No, I don't think so. I just think it will be a different professional.
Yeah, and I guess we're all going to become a technology enabled at some point. In fact, we already have been.
We already are. We already are.
We already are, just more so. And getting back to the AI, that's the part that's a little scary. How are we going to integrate this into the practice? How are we going to learn this? I don't think there's a lawyer in the world that doesn't know how to use email right now.
Yeah, no, I mean, look, we in California rules of ethics and in model rules, there is absolutely no question that the duty to supervise AI is there. It's not as explicit today, it will be more explicit, but the duty to supervise is there. It has been historically broadened from apprenticeship system to vendors to technology to all kinds of things. So I'm pretty sure it applies to AI. What's missing, and I think you have a really good observation, is a how. What's missing is helping educating lawyers, understanding how to assess the gap, how to close the gap, what to do when they cannot close the gap on their own. And the clue is you have to probably work with a specialist when you can. The operationalization of supervising technology and AI and using it properly, the educational and the how component, this is where, bar associations could be super helpful. California Bar can be a lot more helpful on this issue. The ABA can be a lot more helpful, and I can tell you there's a lot of efforts to go there.
Yeah, absolutely. And lawyers generally have an obligation of technical competence. And I think that's going to extend at some point, just like it now extends to having good cybersecurity practices. It's just going to extend to knowing how to use AI tools in your
Absolutely,
practice.
just like you no longer can do a production with metadata in it without thinking twice. That's considered incompetence if you are a litigator. So just like that, we just need to learn and operationalize and help and bring everyone along for this journey. There's going to be a gray area where you may be able to kind of use analog tools, so to speak. But at some point, just like internet, email, it will have to be part of your practice.
All right. Okay, well, Olga, I want to be sensitive to your time. There were a lot of topics we didn't get to. We could talk to you about a number of things around technology, but this is probably the biggest one. So thanks again for being here. This is Roger Royce, 10,000 Startups Podcast. I've been talking with Olga Mack. Thanks for listening.